Okay, I think we'll begin. Right, well, welcome everyone, and thank you for joining us today. Whether this is your first session that you've joined as part of Family Mediation Week, or whether you're a sort of seasoned pro and been joining lots of sessions, or even over in past years, we're very glad to have you with us as part of the programme for Family Mediation Week this year. Firstly, just want to make a few brief introductions. So I'm Paul Linsell. I'm a specialist family solicitor and mediator. I head up the family team at Boys Turner in Reading. As a mediator, I've got over 10 years of experience. I'm fully accredited with the Family Mediation Council, and I'm also qualified to use the advanced hybrid model of mediation, which we'll explain a little bit more later today. I also sit as part of the Family Mediation Week committee, so it's fair to say that I'm very passionate about mediation and all things mediation. I'm absolutely delighted that speaking with me today is Sara Davidson. I suspect Sara needs very little introduction to anyone on the session today. In terms of the world of divorce coaching, Sara is known worldwide. She's an authority on breakup, divorce, and domestic abuse. Sara is also a best-selling author, a podcaster, a speaker, and makes regular appearances on television, both in the UK and in the US. So Sara, thank you for being with us today. I don't know if you want to introduce yourself any further.
I think you've done a great job, Paul. I think pretty much everyone I can see on the on the attendees list knows who I am. So thank you for that. Nice to be here, and really great that so many people have joined, actually, because I think this is going to be a really useful session and essential if you are a breakup and divorce coach. So excited, Paul, excited.
Yeah, thank you. What I'm going to do is I'm going to share my screen, and then we'll hopefully be able to go through some slides. Bear with me. Right. Sara, could you just let me know if you can see that okay?
Yeah, I can see it. Great.
Fantastic. Right, so as it says on the screen, today really is an introduction to family mediation, and it's very much aimed at divorce coaches. In terms of what it's going to be, I'm not sure if that's working. In terms of the session today, what I want to cover is really what is family mediation. So going really back to basics as to what family mediation is, some of the key principles of family mediation, because there are some principles that people need to be aware of, which again sort of feeds into what mediation is. What can family mediation help with? So what actually issues might you be coming across as coaches that you might be thinking, actually, this is something that mediation might help? So what can it help with? We'll then look at some of the benefits of mediation. So why to mediate and the flexibility that mediation can offer, as well as looking at when to mediate. Because as is often the case with these things, timing can be quite important. And then what we'll do is we'll end with a sort of discussion, really. And Sara, I think you'll have plenty to say as well on this in terms of coaching alongside mediation. So again, the role of coaching and how that can really feed in and support the mediation process. We will then have some time, hopefully, for some questions at the end. I think, as Sara mentioned before, the Q&A is open, so please feel free to put any questions in there. And we'll try to get through as many of those as we can. But I think the chat function is open as well. So again, if you want to use that as we're going through, by all means do. Okay, so in terms of mediation, what is family mediation? Well, I think the easiest way of describing it, and it's not always easy, is to describe it as a process, and it is an effective process for people who are involved in family relationship breakdown or changes within their family relationship, and frankly, any disputes that are arising in that. And really, the way to think about mediation is very much as a process. It's something that can hold the hands of the family and guide them through whatever it is that they're dealing with. It's done by an impartial third person, the mediator, and really the role of the mediator is to help the two of them to communicate better and to perhaps even communicate at all about the issues that they are facing, and really, as I say, to sort of act in an impartial way and to guide them through that process. As you can see on the photo, on the picture on screen, I think one way I like to look at it is the role of the mediator is helping people to untangle things. I think very often in mediation, when you get a couple coming to you, there's a lot going on. There's a lot of different issues that they're facing, and actually they're quite tangled up. And there's lots of different things that you have to deal with at different times. And I think, as we'll sort of explore a bit more today, part of the beauty of mediation is that you can kind of get all of those threads together in one big ball and start untangling them and lining them up in a much more ordered way, and help people through that in a much more logical, process focused way, which is great to provide a forum for them to do that. Another thing I put on the screen there about mediation is I always see it as being future focused. I think there's sometimes a bit of a misconception about mediation. I think often when I'm speaking to people, and it might be that I've spoken to one party and they're considering mediation, and then I'm speaking to their spouse, and they are asking me things like, is it about getting back together? Is it about sort of therapy? Is it unpicking what's happened in the relationship? And the answer to that is no, it's not. Mediation is future focused. It's about sorting out the here and now, and building towards a future and making decisions that affect that future. So it is very much a future focused process. I've also put in there that it's about helping people to reach their own agreed and informed decisions. I think, again, it's something which I'll touch on a bit more in a moment, but essentially with mediation, what you're aiming for is that the participants to the mediation, so very often the couple that's separating or facing any issues, are coming to agreements. So effectively, they're the ones that have got to own the process, and we're facilitating it. And I think really very often the way I see my role as a mediator is doing everything to assist them in making informed decisions, and that might be doing all sorts of different things, all sorts of different techniques to try and achieve that. So that's broadly what family mediation is. As I say, it's best thought of as a process, and it's often referred to as a dispute resolution process. I think it's not always about resolving disputes, but obviously predominantly that's when people come to mediation, what it's about. So sort of talked a little bit there about what it was. In terms of key principles of family mediation, I've put on the screen there 4 of the main principles that apply in family mediation, and just talk those through. The first of those is that it's a voluntary process. So in terms of coming to family mediation, it's not compulsory. So again, something which has been up for debate fairly recently is whether mediation should become compulsory, and it's not. So it's very much not a compulsory process at this point in time. Whether that comes in the future or not, it is still open to debate. There is, I suppose, some element of persuasion, I suppose, in terms of people coming to mediation in terms of the legal process, because before any court applications are made, save for a few exemptions, people have to have attended a mediation information and assessment meeting, or a MIAM, and that's really a meeting which is discussing all things mediation, as well as other processes that might be suitable for resolving any issues, and quite often can be a sort of intake meeting into a mediation process. But even then, although you have to attend that meeting, you can go to the MIAM and say, no, I don't want to mediate, and nobody can force you to do that. So it is very much a voluntary process. And I think rightly so, because ultimately, as I said before, if you've got 2 people trying to reach decisions between themselves, if someone doesn't want to be there, well, they're just not going to reach decisions. So it's not going to be an effective process, and frankly, a waste of time, a waste of money. So it's a voluntary process. The next point is that it's a confidential process. And again, this is quite an important point, I think, particularly for some couples, with the transparency in the courts, which I think overall is a good thing for society, but for individual couples going to court, there is increasingly the potential that their information won't be entirely confidential, and it can be reported on. Whereas mediation is very much a confidential process. Nothing will go outside of the mediation room, save for 2 professional advisors. And you would also expect the parties to enter into an agreement at the outset confirming all of that. So an agreement to mediate again, reiterating that it is a confidential process. The third point on there is that the mediator is impartial. Now, I mentioned this before, and just to sort of expand on really what that means, the role of the mediator is different from that of, for example, a solicitor. They're not there to support any particular party in that process. They're there to support the process as the mediator. Now, it doesn't always necessarily mean that it feels to the parties that the mediator is neutral, because part of the mediator's role is to really test what we call reality testing the parties in any positions they have. But the mediator does have to be impartial. They have no interest in what the outcome is. They're not trying to get to a particular outcome. They're just trying to assist the parties in getting to the outcome that they want. So it's very much that impartiality is a cornerstone of mediation. Obviously, if you are acting as a solicitor and you're giving advice, you're not impartial to the person you're giving advice to, because you want to achieve, and indeed the Law Society regulations say that you have to try and act in the best interests of your client. Whereas mediation, as I say, you're really facilitating the process, and as I see it, your duty is to the process and providing the best possible process that you can. The fourth key principle there is that it's the participants that determine the outcome and not the mediator. So again, a sort of distinction there in terms of process. Mediators aren't judges. They have no actual power other than the power to end the process or to adapt the process of mediation. So it's not for a mediator to determine what the outcome would be, nor is it appropriate for them to do so. And although as a mediator, sometimes I'd be offering information and I'd be sort of presenting, okay, this is the sort of things that might be considered, and here's the range of options that you might be considering in any given situation. It certainly wouldn't be for me to try and persuade either party that one is the right option or the wrong option. It's very much for the participants to work out what's right for them. And I often talk about that in mediation with people by referring to fairness, because fairness it's quite a strange concept at times, and it means different things to different people at different times. And so when I talk about fairness, I'll often say to a couple, okay, you may each have differing views of fairness, and there may be a third view of fairness, which is what the law would do. Now, if you ended up in court, this is what would happen, and that's what the law would deem to be fair. In mediation, you're sort of putting to one side that legal aspect of fairness, not entirely, it's always in the background, but really you're inviting the people participating in mediation to try and come to a compromise as to what they both consider to be fair. So as I say, it's very much for them to determine the outcome, and it's them really that's leading the process in that way. Okay, so what can mediation help with? I think, of course, I would say this as a mediator, but the short answer is most things. I've put on the screen there some of the main things. So arrangements for children or any other issues concerning children. Again, you can mediate in respect of that. Likewise, financial issues, whether that be on divorce or an unmarried couple, or even people that have separated, and it might be an issue about child maintenance or something else financial. So that's the sort of the main ones, I suppose. It's pretty much any issues that might be resolved by the court. Mediation can probably assist. The reason I say probably is the sort of exception I would say to that is if there is a factual dispute, and that factual dispute is so material to how things should be resolved. Then going back to the earlier point, as a mediator, I can't resolve that factual dispute. I can't determine facts. Only a court could do that. So it's pretty much most things that a court can do, though. It can also do a lot of things that the court can't do. So I think it's often fair to say that the courts can be a relatively blunt instrument. They obviously have to operate with, okay, there's an application for this issue to be resolved, and this is what the law says it should be, and therefore it's resolved in this way. It doesn't really deal with a lot of other stuff, and there are a lot of things in a relationship breakdown where it's not something that a court would get involved in. So mediation can be really good at dealing with those things. And I think particularly where there are children involved and there's a complex dynamic and there's all sorts of things that might be needing to be thought about and discussed, mediation can really come into its own with that. I've also put on there about extended and blended families. I think, again, the way the law looks at predominantly children issues, again, it is fairly, I suppose, fairly focused on specific individuals in the children's lives. And it's usually looking at concepts such as parental responsibility, so the direct parents, and can sometimes ignore the fact that there are other people in those children's lives that are extremely important, and particularly, as I say, where you've got extended families or blended families in a mediation process, you've got a lot more ability to bring all of that into the mix and actually resolve things in the best possible way. So I think they're sort of the things I wanted to highlight, but I think the main point really is any issues in family law, I think you should be thinking about mediation. I think generally it can help with most things, or at least make some progress in helping with most things. Okay, so why mediate? Or I suppose I could have termed this the sort of benefits of mediation. And I've got on the screen there a sort of list of different things that I believe are certainly benefits to the mediation process. The first one on there is that mediation generally is going to be less stressful than court. Now, that's not to say that mediation is easy. I think mediation is very much not a walk in the park. It is still a difficult process for people to go through. They're having to deal with a lot of differing things that they're having to think about, big decisions that they're having to make, and in some ways it can be possibly seen as being harder than court, because that person is actually taking the onus of making these decisions themselves, rather than handing it over to a judge and saying, okay, well, you make the decision. The couple's saying, right, we're going to do the hard work, we're going to try and find a way to make these decisions ourselves. So it can be a hard process, but in terms of stress, I think I would say it's less stressful than court. I mean, I put my solicitor's hat on and talking to people about going to court. It's pretty horrible, frankly. I think the stress and the strain of going and sitting in a courtroom, I mean, you might be waiting at the court building for most of the day to go into a courtroom, possibly for an hour. And then it's all sort of rushed through and everything's sort of processed, if you like, as well as the combative nature. So you'll have position statements being presented, and very often if you've got barristers involved, they'll be standing up and trying to persuade the judge of different things. So it can be an incredibly destructive and stressful process if you go to court. I've also put on there saves money. And again, I think generally mediation, in terms of resolving things, there is a very good chance it will save the participants money compared to other processes. At one end of the extreme is obviously court. I mean, if you went all the way through court processes, you'd be spending tens, if not hundreds of thousands of pounds potentially on complex disputes. Compared to mediation, where you may just be spending sort of £5,000 to £10,000 on a similar sort of complex dispute. So you could be saving quite significant amounts of money in a mediation process. Again, that has to be caveated a little bit in terms of if mediation is successful, and there is no guarantee that mediation will be successful. But actually the statistics are pretty good in terms of people that go to mediation, in terms of either getting a full resolution to all the issues or at least a partial resolution. And again, something I would say in my experience, whether acting as solicitor or mediator, is people that have gone to mediation, even if you haven't actually resolved things and you do end up in a court process, well, firstly, the chances of ending up in a court process are much lower, because you may have resolved some things and you may then decide to go to, for example, arbitration rather than court to resolve the outstanding points. But also, if you do go to court, you're going to be much more focused. You know exactly what the issues are. You know exactly where you're not agreeing, and you can really short circuit that court process as far as possible. You still have to operate within what the court will insist upon, but you can usually again make that a more focused and quicker process through the court system, even if you've had a, I suppose in theory, a failed mediation. The next point on there is about retaining control, and again I think this is an important one for people. I think when you, again looking at the other end of the extreme, enter into a court process, you are handing over control. You sort of start that snowball rolling, and it will only really stop in certain applications with the court making an order, whether you like it or not. Whereas in mediation, you're very much more in control. You're dictating the pace of how things are going. Both parties obviously have to agree that, and that can be a balance. But you also, it's a bespoke process, so you can fit it around what you want to do. So if there's a particular date that doesn't suit you, well, the court's not necessarily going to care, whereas obviously mediation, they will, and it will be fitted around that, so you've got more control over that. You've also got much more control over outcome. As I said before, mediation is about the participants to the mediation agreeing and reaching outcomes themselves, whereas in court you're sort of handing over that control far more to initially lawyers, solicitors and barristers, but eventually to a judge to resolve that for you. Next point is that it's quicker. Mediation, as I said just now, it can really go at the pace that the parties want. There are still some limitations on that when things need to be done, but otherwise, I mean, again, I say to people, as long as we can coordinate our diaries, we can get sessions booked in and we can make progress. So it is generally a much, much quicker process. I mean, again, in my experience, I mean, I had one fairly recently where relatively complex issues in a mediation, and we were done within sort of 3 to 4 months. Within a few sessions, things were resolved. If that had been going through a contested court process all the way through to final hearings where a judge makes a decision, you're probably talking 18 months to 2 years. So again, in terms of people getting unstuck and moving on with their lives, it is a fantastic process for moving things forward more quickly. Next point there is about helping putting children first. So again, I think with mediation, certainly the way I work in mediation is it's very much child focused. You have to consider the children, and you can almost not physically bring the children into the room, although I'll talk about that a little bit more in a moment. But you can sort of bring the children into the room notionally, and discussing them in any decisions that are being made and considering what that would mean for the children. Which again, I think is generally a really good thing in society, but also I think for the couple that are experiencing mediation, very often that's actually their priority. And I think it's a slightly bizarre thing that other processes don't do that perhaps so much, when ultimately you're trying to act in the best interests of the people going through the separation or divorce. And as I say, most people, the most important thing to them will be their children. But as I say, mediation is very good at doing that. Flexibility, I mentioned before about sort of fitting in around diaries, but there's also a lot of flexibility in terms of how you set up a mediation. There's all sorts of things that you can do to really build it around the people that you're trying to assist in that process. And as I say, it can pretty much do within reason anything you want it to do. So whether you need to bring in third parties into that process, experts, whether you need to be doing it across jurisdictions, different countries, or whatever else it might be, you can pretty much do that with a mediation pretty easily. Longer lasting outcomes. So I think this is a really important point actually, because I think one of the main things for me as to why I think mediation is something I'm very passionate about and really believe in, is that when people go through mediation, do that hard work and get to a point where they say, okay, this is our compromise, this is what we're going to agree. They've bought into that, they've done the work, and because of that, the chances of that sticking and everyone moving on from it is much, much higher, certainly compared to, again, a court situation where you may go to a hearing and a judge makes a decision and you may have one party who thinks I really don't agree with that judge. They might not necessarily be able to appeal it, but they might be really aggrieved. And so they're always going to be looking for any way to sort of backtrack from it or get out of it or whatever it might be, or sort of push the boundaries in it. Or they might just be sort of channeling that disappointment and the fact that they feel aggrieved onto the other person. And then you continue that dynamic, which again, if there's children involved or even if there's not, it is not a healthy thing for the people there. So again, longer lasting outcomes, I think, generally speaking, if people get to conclusions in mediation, they know why they've got there. They might not be happy with them. It's not, frankly, probably quite rare for people to be happy, but they can understand why they are there. And they have consciously chosen to say, yep, I'm going to go forward with that, possibly as the least worst option for them, but they know what they're getting themselves into. And then the final point that I've got in there is about improved communications, and again, it very much depends on the people involved. But I think a byproduct, if you like, of mediation is very often that parents in particular, or even separating couples that don't have children, will be able to communicate better with each other going forward. Particularly important, obviously, where there's children involved. If they can start laying the foundations of slightly better patterns of communications between them, then hopefully that will see them do better in the future. And as I say, particularly where there's children involved, that could be a really important thing for the children. I once had a mediation client who described it as sort of training their brains to communicate with each other in different ways, which I think was a really nice way of putting it. And essentially what she was saying was that they come to mediation barely speaking, and they've sort of gone through that process, and almost by having that neutral party, impartial party assisting them, they've learned different ways of communicating with each other, which they've then been able to take forward. So in a nutshell, lots of good reasons why mediation is a good process for people. Just to sort of touch a bit more on the flexibility of mediation, I mentioned this before, and again, it really is a very, very flexible process. So I mean, I've got on the screen there some of the different options that people can use. So just to sort of explain a couple of those more, in person or remote, obviously it can be done in a building, or it can be done on Zoom or Teams or whatever technology platform that people prefer. So again, I mean, I've got clients where that opens up mediation as a process. So whether it might be one party's in Australia and one person's in the UK, you can still mediate. So it's not a problem. Shuttle or joint sessions. So what shuttle mediation is where you, as the mediator, are shuttling back and forth between the participants, and effectively they don't necessarily come into contact with each other, or certainly at that particular point in the mediation, they're not coming into contact with each other. And again, that can be done in person or remotely in different rooms. Whereas obviously joint sessions is everybody in the same room at the same time. Child inclusive mediation. So this is where the children are actually involved in the process. They wouldn't be brought into the mediation room itself, but a specially trained mediator would speak with the children to really ascertain their sort of wishes, their feelings, anything they wanted their parents to know, because ultimately their views are important. And again, in terms of guidelines on that, the guidelines are that any child over the age of 10 or 10 or over there should be consideration about whether they should be being consulted in mediation, and their voice being heard, because as I say, it's important that they have their say in that. And again, going back to what I said before about longer lasting outcomes, if parents make decisions about a child, particularly an older child, and the child either isn't happy with them or doesn't understand them, again, that's going to potentially cause problems later down the line. The next thing on there is hybrid mediation. So this is one that perhaps does require a bit more explanation. I think the simplest way of putting it is that traditional mediation in family law would require the mediator to share everything with each party. So even if you're operating on a shuttle basis going between the participants of the mediation, you'd have to share anything that was said in traditional mediation. Hybrid mediation changes that, so it allows the holding of confidences. So if I was going into one party, they would be able to share with me something and then say, actually, I don't want the other person to know, but I wanted you to know, so it can help you kind of evolve the mediation and move it forward. There's some limitations on that. So if I was mediating in a hybrid model, I'm not able to hold confidences on anything that's factual. So, I mean, if I had someone turn around to me and said, I don't know, I've got a bank account with £1 million in it, but don't tell him or her, that's not something I could hold a confidence on, because that's factual and the other person would be entitled to know that. Whereas if they said, I've got this bank account with £1 million in it and I'm thinking of giving them half, provided they agree to X, Y, Z, but don't tell them I'm thinking that until we've got a bit further with X, Y, Z, then that's absolutely something I can have in mind. And the benefit of that is that I don't have to tell the other person that, and indeed I wouldn't tell the other person that, but it can help me identify, okay, windows of opportunity for resolving things and moving things forward more quickly. So that's broadly what hybrid mediation is. It's about holding of confidences in mediation, and you require extra training to be able to do that. With hybrid mediation, very often, because it's always done on a shuffle basis for obvious reasons, if it's in a joint, you wouldn't be holding confidence, so everything would be being heard by everybody. It's quite common to involve other third parties in that process, whether it's lawyers supporting, giving advice, or someone else giving some sort of support in that process. And really, that's the last 3 points that I've gone on there, is about involving other people in the mediation process. And again, that's where it's a very flexible process. So we can parachute in an expert into the process, whether that's a legal expert. So you might get a barrister or senior lawyer to come in and give a view on something from a point of law. It might be a financial expert, whether that's a financial advisor, a pensions advisor, mortgage expert, an accountant dealing with business, whatever expert you need. You can kind of get those people into the process and help unlock things and move things forward. Likewise, lawyers, as I say, you can get lawyers involved in the process and again, be providing that advice in real time to help move things forward. And then the final one I put on there is coaches. And I think it should be being encouraged and hopefully becoming more normal for coaches to be becoming actually involved in the mediation process directly, as well as, we'll talk about this more in a moment, supporting alongside it. And I think I can certainly see a real benefit, particularly in certain circumstances. For example, if there was an abusive situation where you might be doing a shuttle mediation, probably using a hybrid model, and having a coach there to support someone, as well as support the process in identifying risks and when there might be abuse. So again, I think coaches being involved is a really important thing for the future of mediation. So really, just before we talk about in more detail coaching alongside mediation, the last thing I want to touch on is when to mediate, because I think this is a question I get asked quite a lot. The short and perhaps slightly unhelpful answer is any time. Mediation is always, I think, open and should always be on the table. I think, as I said there, early is generally best. I think the earlier, if I'm mediating, the earlier I get people into a mediation room, the better, because less entrenched in their views, things haven't got as bad, if that's the right way of putting it. And I think, as I say, the earlier you catch that, the more you can do, and the easier it is to not have to unravel things, particularly if there's court and things like that, where it can sometimes add the temperature going up and up as the dispute becomes more entrenched. But I've also put there, don't be put off though. Although early is best, just because people are in court proceedings, that's not a problem. Indeed, right up to the final hearing on any given application, you can still mediate it. You can still be trying to resolve things. And indeed, I have mediations where parties have got final hearings booked in and they're on a deadline. And if they don't resolve things, they'll be going to court and the judge will be making a decision for them. So you can certainly still mediate in those circumstances. One party believing the other won't mediate. And again, this is something, if I had £1 for every time I heard it, I wouldn't be needing to work. I think most people in relationship breakdown assume that the other person is going to be unreasonable. Some are right, some are wrong, but it's often the case where people are saying, no, we can't mediate because the other person is never going to agree to anything, or they're never going to engage, or they're not going to engage properly, or whatever it might be. Don't be put off by that. There may be circumstances where mediation isn't suitable, and again, part of the process of the intake into mediation, that MIAM process that I mentioned before, is to screen that and to understand if that is going to be a risk. But it's something which it's best having the discussion and seeing if that's an option for the parties. Very unusual to not hear one party thinks the other won't mediate, but very, very common that actually the other party does want to mediate, and actually they will mediate effectively. Long-standing disputes. So again, I mentioned before about early being best, and entrenched makes it harder. That doesn't make it impossible. So even if the dispute has been going on for a very long time, that doesn't mean mediation isn't going to be possible. Likewise, poor communication. So again, very common actually to have people coming to mediation and they won't even speak to each other, or they won't even speak in the same room, or whatever it might be. And again, part of mediation is we can rebuild communication channels, or open communication channels if they've been closed completely. So don't be put off by that. It doesn't have to be the parties that are really amicable and getting on brilliantly that come to mediation. In fact, it very rarely is. And likewise, high conflict. So again, we are used to dealing with conflict. That's part and parcel of being a mediator. And so high conflict doesn't act as a barrier to that. And indeed, I would say some of the mediation processes and setting them up can be really useful for that. So coaching alongside mediation, I mean, I've put on there a couple of points from me, but I think rather than hearing me talk any more about that, I think Sara, perhaps you could share with us your sort of experience of coaching alongside mediation, and then I can see quite a lot of questions coming in, so perhaps we'll then come to some questions.
Yeah, so I'll be quick, but I just thank you, Paul. I mean, I think that's really, really useful for us all to hear. One of the things about mediation is that we can play a really big role as a coach alongside clients going through it. And many of my clients have been through mediation, many have been through court, but I think understanding the process is absolutely key for us. And that's your number one point. It's also mine, because if we understand better, then we can help them prepare for it. So one of the things with mediation is that obviously you're going to be dealing with their ex in the same place. Now, I understand that with court, it's going to be maybe worse because maybe the tensions are heightened, but still the emotions towards the ex aren't going to change. Being in the same room, having to be on the same Zoom meeting can trigger a lot of negative emotions for clients. So we as coaches really need to bear that in mind. Just because we're saying it's mediation and it's slightly easier and it's more friendly and it can improve communication, it will still be difficult for many, many clients just to be in that room with their ex, or to be in the same building, or to be on the same Zoom meeting even. So first of all, understanding, I think, that what Paul said about the different options, how it works, the pros and cons, why you would do it, and the benefits of doing it are key. Now, we obviously don't give legal advice, but clients do ask questions of us, like, what is mediation and how does it work? And is it instead of you? And how would that work? So all those kind of questions, it's really helpful for you to have been on here and understand that process now. So I hope you took some notes. I know Paul might share this with everybody afterwards anyway, so we've got those notes too. And I think one of the things with helping clients prepare for any sort of situation like mediation, I always think, because from my own experience going into a mediation, I thought it was going to be very gentle and very easy. And I know Claire Sparksman's put a Q&A question in about mediation. I had a very similar experience, and we'll come to that, but it wasn't a great one. But I wasn't prepared for that, so it really knocked me offside. Now, I think one of the things we can do is prepare them worst case scenario. Almost like, I mean, we definitely need to do that for court, because that can be really terrifying. We don't want our clients falling apart in the box. I know that's what happened to me. When you go into a really tough, stressful situation and you've been told, just be yourself, you'll be fine, answer the questions. That isn't enough preparation, in my opinion, for clients. They need to know worst case scenario, so they build up their resilience. And zip up their Teflon suit and really are prepared for it. And anything better than that is a bonus, okay? But we don't obviously want to scare them or frighten them, but just by educating them in the way that where you've built rapport and empathy with them, you can explain. Like some cases are not as great as others, but let's go through it. I think asking them what their biggest concerns are about it first are going to be key, and then working on a plan to address those. Okay, so you're working on not your assumptions, but what they're specifically needing. And then you can create that plan to help them overcome those, or maybe get some of the answers to some of those challenges before they go into mediation. The work before is really understanding that they know their case and they've gone through that, so they're confident. Now, obviously, they'll be doing that with a legal advisor, but some people might want to role play some things with you, questions and things like that. And understanding, you know, why they're doing it. Some people want to understand the financial cost versus the emotional cost of going to court as well. So we can talk about those pros and cons with them. I think understanding how it works dials down those negative emotions of overwhelm and fear for clients. So even though they may have heard it from somebody else, like a lawyer or a mediator, sometimes hearing it from us, maybe in a sort of less legal terms, more sort of just understanding the process can really help. And understand that communication, how it works with that mediator. Like, what happens if they want to leave the room? Like, we're really dealing with those emotional issues. Like, what happens if it gets too much for them? And how do they want to come across in the room? What's their, you know, what do they want to be seen as? Do they want to be seen as friendly or firm? They need more clarity about their situation. You know, how are they showing up as cooperative? Are they going to be showing up as defensive? And also having an escape plan as well. I know that sometimes tensions can rise even in mediation. And so having a plan, if it gets too much for you, what are you going to do? So all these things are sort of safety plans that we can put in place for them. And if we don't have the answers, then that's something that they could speak to the mediator about in their MIAMS meeting and check with them, and I'll get those questions answered. As far as tools and techniques to help them with that, I mean, obviously visualization and mind movies is going to be great for practicing it going well, because it'll help them dial down the fear of the unknown and practice some of those areas they might be scared of. Getting more clarity on what their outcomes are from that, maybe more generally rather than specifically about the legal outcomes, but getting some clarity on what they want and how they want to feel when they're done. Working on body language tools as well, helping them to manage their and be aware of their body language during that, and how they can shift and maybe have a power move to make them feel a little bit more confident or a little bit more brave at times, or less emotional when they need to. Having some go-to phrases as well when they hear information that makes them uncomfortable and that everyone's waiting for an answer. Like, how do they fill those difficult silences? What have they got as a practice, rehearsed phrase to come out with? Like, okay, that's interesting. Let me think about that for a moment. Little phrases which can help them, buy them some time to think. And how they might be able to sort of shift the dynamic there and maybe feel a little bit more in control and take their power back if they need to. So I think giving them and arming them with a toolkit of emotional tools to help them with that in mediation can just help allay some fears there and make them feel like they're a little bit more in control and more confident before they walk in the door. But then we also, as coaches, have that more logistical side as well, more practical tips, like, what are you going to wear? Like, you know, what time does it start? And do you want to get there a little bit early and have a coffee next door before you go in? Or are you going to go up with a friend? You know, actually helping them plan that day so that they've got a plan of action. I know when I'm training my coaches, we always talk about, you know, making sure you make it as simple as possible for them to action that plan. So really thinking through all the eventualities. And also, don't forget afterwards. If any of you, and I know a lot of my coaches have been through this themselves, which is why we do this, but actually when you're coming out of that mediation, you know, if it has been a little bit difficult, or even if it's gone well, there'll be a lot of built up negative emotions that you need to get rid of. So, you know, if they are upset, or maybe they're angry, or maybe there's something that's happened that's worried them, what's the plan? You know, what's the plan? How are they going to decompress? How are they going to release those negative emotions? Are they going to have a friend waiting for them? Are they going to travel home on their own? You know, what is the plan? Are they going to make a call to somebody? So we need to have a plan of action to help them afters as well. And then yesterday when I was with Paul and Sarah on another of these webinars, we were talking about, should a divorce coach go into the room, and what can you do during that actual mediation session? Now, again, that's going to be a bit of a personal decision, but personally, me, I wouldn't work with two people. I only work with one, because I find it difficult to understand how we can maintain our client's best interest if both people have opposing views and are trying to come to the same outcome. We're not the mediator. we're there for emotional and practical support. I think waiting outside, if you go along, I know a lot of my coaches go along to mediation, and that helps with the before and after, obviously, but also they've got someone to come to if they need a bit of a breather or want to go for a walk around the block and take a break. So you don't actually have to be in the room, you can be there supporting, or you can just be on the phone as well. So lots of different options. Again, it's finding out what your client needs. Everyone's different, everyone needs different levels of support, different types of support. So tap into that, find out what they want, find out what they need, find out what their biggest concerns are, and then put that plan, which covers before, during, and after, together for them. So that would be my advice on how to help your clients through that. So Paul, do you want to go to some of the questions?
Yeah, I mean, I think just 2 points just to add to everything you said, and I agree wholeheartedly with everything you just said. So I think the 2 points I would add in terms of coming into the mediation sessions, I would agree. I don't think as a mediator, I would necessarily want is probably the wrong word, but want a coach there in a joint session, because frankly, they might as well go and speak to someone else and seek that sort of support elsewhere, whether it's group therapy or whatever it might be. But what I do think is the coaches coming in where we're acting on a shuttle basis, and so they're supporting one party, but within the process, I think that's something that can be really helpful. The second point I just wanted to make very quickly was I put on the slide there about patience with the process. I think, again, in my experience, mediation can sometimes be a bit of a slow burn. I think people very often come to the first session and walk out of it thinking, well, we've made no progress there, because they haven't really sort of understood how all the different strands and everything's kind of coming out, and it almost looks and feels, I think, to them as, oh, there's more problems than we walked in with. And I think, again, coaches understanding that and coaching people through that, both with what you said in terms of preparing them for it up front, possibly during the sessions or even after the sessions, I think is, again, a really important thing. But yeah, let's go for some questions, because I can see there is an awful lot. Sara, do you want to fire questions at me, or how do you
fire
want
questions
to do
at
it?
you. So Julie's asking, is it a mediator's role to advise a participant that they cannot get legal aid? Would one party's legal aid cover the cost of the other participant?
Yep. So in terms of funding, I mean, first thing to say is that legal aid is available in certain circumstances for mediation. You would have to have a mediator that offers legal aid. Now, I myself don't, so I'm not necessarily the best person to answer the specifics on legal aid. But it's certainly a mediator's role to be considering that and signposting people if they might be eligible for legal aid. That is something that should be being considered. Another thing to mention on that as well is funding of mediation. So there is a mediation voucher scheme, and essentially what that means is that parties can get up to £500 contribution, non-means tested, towards mediation if there are any issues concerning children. And again, that's something where you have to use a fully accredited mediator. It has to be accredited through the Family Mediation Council, but it does give people access to that. And I mean, it's something I use quite frequently, and that can sometimes be the difference between starting mediation and not. So that £500 can pretty much cover a first session of mediation. So it can be a really useful thing for people as well.
Yeah, that's really good. Okay, we've got 2 questions here on similar topic. So I'm interested to know Paul's view on what a mediator does where he or she senses one party is being manipulated or in a toxic relationship. And the other one is, what would you advise if a mediator overtly sides with one of the parties? The mediator is supposed to be impartial, as you said. My mediator, male and chosen by my ex-husband, suggested in a joint session that my ex could not have kicked me in front of the children without them completely waking up. Also, that he wouldn't have smashed his own laptop. He did. I saw it. I felt cornered by them, ganging up on me to agree an interim maintenance sum. I wrote a letter to him to complain afterwards, but he denied my experience.
I mean, dealing with the specific point first, I mean, it's not for me to comment on the specifics of other mediators, obviously, but I think to me that doesn't sound quite right or appropriate. As I said before, the mediator, certainly when I'm mediating, I'm not there to make determinations of whether something did or didn't happen. And I think in that circumstance, it would have been a case of saying, can we work around this? So you may have different accounts of the same event, or even that the event didn't happen or did happen. But can we work around it? If you can't, and if that point is going to be so material to what should happen next, then probably one of those situations where mediation isn't appropriate actually to move forward. But certainly, I mean, as a mediator, I think sometimes there's a fine line between offering balance, and I think again that sort of balance in how you're questioning often. Each party to the person you're asking questions of might not feel very balanced, and sometimes it might be that you're asking 10 questions of one person on a point and one question of the other, and it's quite a difficult assessment sometimes as to where you put that time in. But as I say, it should always be impartial. There should never be, as a mediator, saying, oh, this did or didn't happen, or sort of getting involved in what the outcome is. It's just about reality testing things. It's about making sure you're getting to the bottom of things. And as I say, sometimes that does mean you're questioning one party a bit more and asking and delving into that a bit more with one party, or spending more time with one party on a shuttle mediation. But no, it doesn't sound quite right on the specifics of that. No. The other question in terms of if you sense someone is being manipulated, I mean, let's use the word abused. I think as a mediator, again, it's something where it's a bit of a judgment call. I mean, ultimately, the only nuclear option you have as a mediator is to end the process, and so you sort of have to be quite careful, I suppose, because even if that is the case, and even if someone is being manipulated a little bit, it doesn't mean that that's not the right process for them. And so ending the mediation isn't always the right thing to do. I think what I would do, firstly, you try and screen it at the outset. So in the MIAM, you'd be trying to screen for those sorts of things, and you'd be signposting and sort of questioning it. I think if it was something where it was coming up in that way, I think what I would be doing is firstly making sure you weren't in a joint session anymore, so trying to get into shuttle sessions as quickly as possible. And if the person that's then doing the manipulating is very hesitant and reluctant to do that, I think again you may have to think about ending that process. But if you get into that shuttle based process, particularly if you're in a hybrid model, I think it'd be having a discussion about the behaviours and just trying to ask a lot of questions, and then ultimately signposting that person to support, to consider those behaviours further, I think would be the way I would approach that. But I think let's be honest, I mean, domestic abuse in any process, including mediation, is a difficult thing to manage. Particularly, and again, it's part of the conversation we had a little bit yesterday, Sara, but if the abuse is sort of physical abuse, then yes, of course, mediation can manage that quite easily. The parties never have to see or come into contact with each other. But when it's more subtle, coercive behaviour, controlling behaviour, that is difficult, and it is difficult for mediators. I think if there are elements of that, the mediator is aware. I think making sure the right professionals are involved, such as yourself, Sara, or someone else, is absolutely vital.
I mean, I would just point out there's very unlikely to be physical violence without coercive control, but that's just a DA point.
Yeah.
I mean, there's so many questions, but I think we'll have to go to shorter answers. But is there, I'm just sort of, Liz's question, I think you've answered some of it, but is there a compulsory domestic abuse training? Seeing as you're saying a lot of the mediators are then screening themselves, is there compulsory domestic abuse training for you?
Yeah, so it features as part of the initial training to become a mediator, and then if you're an accredited mediator, you have to reaccredit every few years, and you have to, within that, produce records of training that you've done, which would include training on domestic abuse.
Okay, thank you. Can children attend a mediation between their parents? I'll just put these questions together. I think you sort of covered one. Children can be part of a feedback session to their parents. And then for a child inclusive, would a report be made similar to a CAFCAS report, or is it more with a chat with the child inclusive mediation?
No, it wouldn't. So with the child inclusive mediation, the children speak to the mediator, and the mediator will only share and feed back to the parents what the children are comfortable and happy for them to feed back. So it's about them having a voice. It's not about the mediator producing a report or doing something like that. I mean, there are others that can do that, independent social workers, for example, but that's not the role of mediator in child inclusive mediation.
Okay, Thank you. Just to clarify, who initiates the process of mediation, assuming a solicitor cannot be a mediator if he represents one of the parties? What is the level of awareness for mediation, and do the courts see this as a favourable option in divorce, assuming it ends in divorce?
Few points in that. I think, I mean, in terms of who initiates mediation, no, if you're acting as solicitor, you can't be mediator as well, because there'd be a conflict of interest. So you can't do both roles. In terms of who initiates it, it can be anyone. I mean, I get referrals, so started work either from the parties themselves, it can be from their solicitors, it can be from coaches, sort of suggesting mediation. I think in terms of the awareness levels of mediation, I mean, the very purpose of Family Mediation Week is to try and promote mediation more. I think it's definitely growing. I think it's far, far better than it ever has been before, but it could certainly be improved still. I think the time when people go to mediation first will be the time where it's really got to where it needs to be. In terms of the courts seeing it favourably, yes, I think is the short answer to that. Certainly any judges I've ever spoken to generally see mediation favourably. And as I said before, it's a prerequisite to many court applications that you have to have at least understood what mediation is and made a conscious choice not to go to it if that's what you're doing before you can go to court anyway.
Thanks, Paul. What are the requirements for a mediator who can speak with children?
So you have to have done specialist training. So you'd have to have a sort of specialist ticket to be able to do that. And so, yeah, again, it's just extra levels of training, and there'll be extra sort of DVS level checks and all that sort of stuff before you'd be able to do that.
Okay. When did the voucher scheme come in?
Oh, you're testing me now. To be honest, I don't know off the top of my head. It's been a good few years. It's been extended 2 or 3 times now, and I think it's just been extended. I don't know if Helen or someone's on the call to answer this who'd know better than me from the FMC, but I think it's been extended to possibly the end of this year or possibly even into next year now. But it's a good scheme. I think it's everyone should be thinking about that.
Yeah, definitely. And last question, are there any additional costs for a shuttle meeting? Are they more expensive than joint?
Short, rather unhelpful answer is it depends. Inherently, normally, a shuttle mediation is likely to be a little bit more expensive because certainly if I'm explaining concept as the mediator and sort of talking through things, I'm going to be doing that twice because you're in separate rooms. That being said, sometimes shuttle mediation can speed things along because, like I said before, with sort of hybrid model in particular, where parties are in the same room, sometimes the communication dynamics get in the way, and actually it's sort of a little bit of posturing and sort of not wanting to really say too much until the other person said something and things like that. So conversely, it can speed things along, but it depends. I mean, it really depends on the circumstances as to which is going to be better.
Great, thank you, Paul. That was really interesting. I know I found it fascinating. I'm sure everybody found that interesting. I hope everyone's taking loads of notes.
Pleasure. And I mean, if anyone wants to contact me, I don't think my screen's stopped showing. I'm just going to share it again. My details are on the screen. I think yours are there as well. So if anyone wants to ask any questions, there we go. If anyone wants to ask any questions, I appreciate there were some extra questions coming in. Very happy to take those questions. You can reach out to me. All the various details are there. Likewise, just to point out, Family Mediation Council website. So that's something that's got a whole load of information on there about mediation as well. Again, details on the screen for you there. And again, there'll be lots more sessions happening throughout Family Mediation Week. So please do join us for one of those if you can. Right. Thank you everyone for joining and enjoy the rest of your days.
Thank you.
Thanks, Sarah.